Hi, I'm Erica Cicero from e.cicerolaw LLC, here with your estate planning made easy moment of the week. In Louisiana, when a person dies without a valid last will and testament, that person is said to have died intestate. Therefore, this person's estate will be controlled by intestate succession. Plainly, this deceased person's property will be distributed under Louisiana intestate law, and not necessarily how the person would have wanted the property distributed. I should note that the manner in which intestate property in Louisiana is distributed is mechanical. There is virtually no room for alternative division of assets outside of the law if the person dies intestate. First, let's do the most common division of assets. The deceased dies while married and has children. We must determine what property is community and what property is separate. Louisiana, unlike many states, follows a community property system. Under community property, a person's assets are either community or separate. If a person is married, the intestate distribution process will require the court to determine what property is community and what property is separate. In my last video, I briefly touched on what is community and what is separate, but let me do a quick overview. Louisiana defines separate property as property acquired by a spouse prior to the marriage, property acquired by a spouse during the marriage, but only with separate funds. Community property is generally assets, incomes, and debts acquired by either spouse during the marriage. So first we determine what is community property and what is separate. The separate property will go to the deceased's children, not the spouse. Each child will share equally in the property. If any of the children are deceased, then the grandchildren will inherit by the root, meaning they will divide their parents' shares of the inheritance. For example, Bob has 3 children, Anne, Charles, and Nicole. Anne passed away before Bob, but left 2 children of her own. Anne's 2 children will divide Anne's 1/3 between themselves, meaning those 2 children, Bob's grandchildren from Anne, will inherit 1/6 of Bob's separate property. Next, the community property is distributed to the spouse and the children. The surviving spouse is given a usufruct over the deceased's 1/2 share of the property and has full naked ownership of his or her 1/2 share of the property. This usufruct will end when the surviving spouse either dies or remarries. At that time, the assets pass directly in full naked ownership to the surviving spouse, who owns 1/2 outright as naked owner, and the other 1/2 to be divided equally between the children in the manner as the separate property is divided. Let me break it down for you. Bob is married to Lori, and they have 3 children. Bob's assets include $1 million separate property in a savings account he inherited from his grandfather. He also inherited a family beach home in Destin worth $200,000 that his family uses as a vacation home. In addition to this separate property, Bob and Lori have a home and property in Mandeville, valued at $750,000. They also have various bank accounts that value $5 million. Bob's 3 children would inherit the $1 million and the beach home that is divided equally between the 3 of them. Upon Bob's death, Lori no longer has the right to the beach house unless her children allow her to use it. Lori owns 1/2 of their home in Mandeville as naked owner, as well as 1/2 of their various bank accounts as naked owner. For the rest of her life, or until she remarries, she will have a usufruct over the other 1/2 portion of the home and the bank accounts, meaning she can use the property and money, benefit from them, such as spending profits from investments, but she cannot destroy the property. Please refer to my previous video from last week for an explanation about usufructs. I went into great detail about exactly what a usufruct is, which might help you understand this a little more. The next scenario that's kind of common would be if a person is married and does not have descendants. In this instance, the surviving spouse will have full naked ownership of all community property. The deceased's separate property will go to his or her siblings as naked owners, with the parents having a lifetime usufruct. If there are no siblings, but the parents survive the deceased, then the parents will inherit the deceased property, separate property, as naked owner. Borrowing from my previous example, if Bob and Lori are married, but they never had those 3 children, they own their community property home in Mandeville and their various bank accounts, valued at $5 million. Bob has separate property of $1 million and a beach house. If Bob has siblings, those siblings will inherit just as the children would the separate property. They would equally divide the property between themselves and Bob's parents, would have a lifetime usufruct of the beach house and the money. However, if he has no siblings, his parents would inherit entirely as naked owners. Lori would have full naked ownership of their community property without the burden of a usufruct over their home and their various community bank accounts. But what would happen if Bob had no siblings and his parents were deceased? This is the only instance where Lori would inherit fully Bob's separate and community property as naked owner. In my next video, we will explore what it looks like when someone has a usufruct over community property, such as in my example with Bob and Lori, and that property is simply money. Can Lori spend $5 million that she and Bob saved for their retirement during her lifetime? Or does she have to save $2.5 million that her children have the right over as naked owner? If you're interested in creating an estate plan so that your property does not fall into intestate, please contact my office. My contact information is listed below. If you haven't done so already, please like and subscribe for more videos like